My name is David Perdue, and I'm the Trademark Wahoo. Today, I'm going to talk about trademark infringement and the various approaches that trademark owners take when addressing a trademark infringement. As I've talked about in other video blogs, trademark infringement requires a determination of who owns the trademark and whether or not the second user has a mark which is confusingly similar to the trademark owner's trademark. When we're looking at similarity, we have to consider two different things: the similarity of the trademarks themselves and the relatedness between the products or services that the marks are being used with. So I'm the Trademark Wahoo, and I post video blogs which are educational and, I hope, entertaining. Trademark Wahoo on plumbing products, for example, would not present a conflict or an infringement of my Trademark Wahoo trademark for blogging services, because someone who's familiar with my Trademark Wahoo blogs would not think that Trademark Wahoo plumbing supplies have anything to do with my business. The first step in the process of deciding how to address an infringement is to determine whether or not there is an infringement. And over the years, I've noticed that there are drastically different approaches that trademark owners use when addressing a trademark infringement. I've found some interesting examples in the craft brewing industry. At one end of the spectrum, we have the Lagunitas Brewing Company and the Sierra Nevada Brewing Company. Both of these breweries made an India Pale Ale beer. India Pale Ale is not a trademark. It's actually a kind of beer. And if you enjoy beer, I'm telling you nothing you don't already know. So India Pale Ale doesn't indicate the source of a beer. It's simply a kind of beer. IPA, like India Pale Ale, is not an indicator of source. It's not a trademark. It is an abbreviation for India Pale Ale, and it has no trademark function. It's simply a way for a brewery to inform beer drinkers about what kind of beer is in the bottle. Sierra Nevada's India Pale Ale had been out on the market for many years, and Sierra Nevada decided that it was time to freshen up the label. And in doing so, it changed the size and position of the letters IPA. To the chagrin of Lagunitas Brewing Company, IPA was in a similar position on the new Sierra Nevada label as it was on the Lagunitas beer label. The size and font were somewhat similar, and Lagunitas decided that the new label of Sierra Nevada was too similar to the Lagunitas label, specifically as to the letters, the abbreviation IPA. So Lagunitas went and fired off a lawsuit, filed it in district court, and then contacted Sierra Nevada. Because IPA isn't a trademark, beer drinkers were puzzled over this challenge. They thought that Lagunitas was being ridiculous. Apart from the IPA on the two labels, the labels were otherwise unsimilar. They had a different brand name or trademark for the IPAs, and they had different patterns and backgrounds. Really, the only similarity was the size and position and font of IPA. The social media response to the challenge of Sierra Nevada by Lagunitas was, to put it mildly, very strong and very strongly against Lagunitas. People said things like, "You're suing over the font and the kerning of the abbreviation IPA." The response was so intense that within 48 hours, Lagunitas withdrew its lawsuit and made an announcement that it wanted to get along with Sierra Nevada. So this is an extreme response to a perceived infringement. The response was so strong that there was a backlash. And the backlash was so substantial that Lagunitas backed off of its claim of infringement. Well, the craft brewing industry gives us another example at the opposite end of the spectrum as to how trademark owners can deal with perceived trademark infringement. In this case, we have the Russian River Brewing Company and the Avery Brewing Company selling their craft beers under the identical trademark Salvation. This had gone on for a number of years before either company realized it. Instead of a lawsuit, the owner of the Avery Brewing Company called up the owner of the Russian River Brewing Company and said, "Hey, here's a thing. We're both selling a Salvation beer. We should probably get together and talk about it." So they did. Vinny at the Russian River Brewing Company invited Adam of the Avery Brewing Company to come over to his brew pub and sit down and have a beer and talk about trademarks. Well, I wasn't quite sure how many craft beers went into the discussion. It wasn't a negotiation so much as it was a discussion. And they didn't try to figure out who had the superior rights to the trademark Salvation. It occurred to them that they might get together and blend the Russian River Brewing Company Salvation beer with the Avery Brewing Company beer and sell it under a jointly owned trademark. At a point well into the evening, when the decision was made to make a single beer, a blend of the two Salvation beers, the topic turned to, well, what trademark should we use on the blended beer? Legend has it that Vinny's significant other leaned over and said, "Well, I have an idea. We could call it collaboration, not litigation." I find this to be a very interesting approach. Two companies that would rather be involved in brewing beer than trademark litigation. I think the new trademark, collaboration, not litigation, says a lot about the way these two men ran their brew pubs and how they felt about lawsuits and litigation attorneys, and their passion for beer overcame any thought either one of them had about challenging the other's use of the Salvation trademark. It's important to keep the eye on the prize, which for any business person is making and selling a product. Trademark litigation can be a huge drain on resources, and the consequences can be disastrous. If the litigation is pursued to its natural end, one company is going to be ordered to stop using the trademark. Collaboration, not litigation, might be the best answer in resolving a trademark dispute. That's all I have today, but please remember, you'll do better in Toledo.